Hi guys, ever notice how the wealthier somebody is, the more likely they are to get sued? You'd think having a big insurance policy would be enough, but it's not. In fact, it might just be the thing that paints a target on your back. This is the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. And in this video, I'm going to show you why insurance alone isn't nearly enough to protect you well, and what the rich are really doing to stay safe from predatory lawsuits. So if you're a high net worth individual or on the way there, you're going to want to stick around for this one. Let's get into it. Most high-income professionals and entrepreneurs are told, just get a good insurance policy. So they do. Umbrella policies, malpractice insurance, liability coverage, the works. And it is a good start. It's smart. You should absolutely have insurance, but here's the catch. Insurance companies are in the business of collecting premiums, not paying claims. So when there's a big claim, when the stakes are high and your reputation or your life savings is on the line, the incentives flip. Suddenly, your insurer is no longer on your team, they're in the risk management mode. Let me give you a story. A California surgeon with a net worth of around $9 million had a $5 million policy, and this was a malpractice policy. Now, he was sued for $4.2 million after a post-surgical infection went south. Now, you'd think insurance would cover it, but the insurer argued that the infection was a pre-existing condition the surgeon failed to note and denied the claim. So the case dragged on, and the plaintiff's attorney uncovered the surgeon's rental properties. Without a protection plan in place, they were up for grabs. And this isn't a fluke. A 2022 report from the American Bar Association found that over 22% of malpractice claims over $1 million are either denied or partially paid by insurers. And once there's a coverage dispute, you're fighting two battles now, one against the plaintiff and one against your own insurance company. Of course, you pay your bills faithfully, but when it comes to time to pay out, they fight you tooth and nail. It is so common. Now, here's the core problem for wealthy individuals. You have more to lose, and people know it, and that makes you a magnet for litigation, especially if your name is tied to multiple businesses, properties, or other investments. In fact, a Wall Street Journal article reported that over 50% of all lawsuits worldwide take place in the U.S., yet the U.S. only makes up 4.2% of the global population. Why? Because we've made suing rich people into a national pastime. So when you have assets, you become an opportunity. And when the plaintiff's attorney finds out that your insurance has a $2 million cap and you have $8 million in unprotected real estate, they're not stopping at the policy limit. They're going after the rest. Insurance doesn't stop a lawsuit from happening. Now, it might slow it down, but it won't stop an aggressive lawyer with a cent for money. One Florida business owner I worked with had a $10 million umbrella policy. A drunk driver crashed into one of his trucks, injured a passenger, and blamed the employer for negligent maintenance. Now, the plaintiff's attorney ignored the policy and sued for $25 million, knowing full well that his assets far exceeded the policy limits. So let me make this clear. Insurance pays if it wants to. Asset protection pays because it's legally structured to stop the bleeding before it starts. Now let's talk about the hidden landmines in insurance policies. There are the fine print exclusions that most people never read until it's too late. There's the intentional acts exclusion. If the plaintiff claims you acted intentionally, even falsely, the insurer may deny coverage, and all they need to do is allege malice or willful misconduct. Next, there's punitive damages. Many states prohibit insurers from covering punitive damages, and this means that even if you're mostly cleared, you could still be on the hook for millions in punitive awards. Next up is excess coverage denials. Umbrella policies often exclude certain activities like owning short-term rentals, running a business, or serving on a board of directors unless disclosed in advance. Let me give you a real case. A dentist in Texas was sued for battery, like as an assault and battery, by a patient alleging unnecessary physical force during a procedure. The claim wasn't even proven, but because battery is considered an intentional tort, the insurer walked away. He ended up settling for $900,000 out of pocket. This is where asset protection comes in, because when you've moved your personal and business assets out of your name and into legal vehicles like LLCs and offshore trusts, those assets are no longer yours on paper, and in most cases, they're legally out of reach. Now, the wealthy don't just rely on one line of defense, they use a two-pronged approach: insurance and asset protection. Now, here's what it looks like. First, they use insurance to fund the fight. Legal fees, settlements. Insurance helps with the day-to-day expenses of litigation. Second, they use asset protection structures to make the fight not worth it. So when a plaintiff's attorney sees a lawsuit is going to take 3 years and cost $500,000 to litigate, and that your assets are in a Cook Islands trust with a Cook Islands LLC inside of it that holds a Swiss bank account protected by a trustee company law firm that is legally forbidden with complying with U.S. court orders, they walk. And we see it time and time again. I've been setting up these structures for nearly 30 years, and the formula that works best, especially for high net worth individuals, is this. You set up a Cook Islands trust represented by this purple box here. Then we set up a Cook Islands LLC represented by this light blue box here. You remain the manager while the waters are calm. And if and when trouble strikes, our licensed bonded trustee company law firm can step in to protect you. U.S. courts can't touch it because U.S. courts don't have jurisdiction over our law firm in the Cook Islands. We also record equity stripping liens payable to the LLC inside of your trust. These are against real estate and other assets. And if needed, we have a third-party lender purchase these mortgages and liens and put the proceeds into your offshore trust. So bottom line, if you structure it right, you don't need to hide assets. I mean, hiding doesn't work anyway. You simply make them unreachable. And you're not being dishonest, you're being smart because the law allows you to protect what's yours before a judgment is entered. Now, let me say this again. You cannot wait until after the gavel drops and they file a judgment and they put a lien against everything that you own, because at that point, asset transfers are too late because everything's encumbered. It's also called fraudulent conveyance. But if you do it early, before the lawsuit lands, in my experience doing this for 34 years, these legal structures are nearly bulletproof. In the asset protection business for 34 years, setting up Cook Islands trusts for 30 of those years. So let me tell you about one of our clients, a tech entrepreneur in California. He had just sold his company for a high 8-figure sum. Young guy in his early 40s. He wanted to enjoy his life and keep his money safe. So we set up a Cook Islands trust. We put an LLC inside of it. His brokerage accounts were held in a Swiss bank account, and we put his crypto holdings in the Swiss bank as well. So he stayed in control of the LLC inside of the trust as the manager. So 2 years later, guy gets hit with a lawsuit. A former employee alleged wrongful termination and sexual harassment. Totally baseless nonsense. But it didn't matter. The lawsuit was filed. The plaintiff's attorney starts sniffing around, finds out this guy owns almost nothing in his name, tries to subpoena the Swiss bank account, gets denied. Tries to enforce a U.S. court order in the Cook Islands. The trustee doesn't even flinch. Why? Because the Cook Islands Trust has legal walls U.S. judges can't penetrate. The law there specifically prohibits enforcing foreign court orders, including U.S. judgments. And in the end, the plaintiff's attorney settled for pennies. So this one structure we see right here saved him $3 to $5 million and years of stress. So what should you do? If you're in a high-risk profession, a doctor, a lawyer, business owner, real estate investor, or a public figure, this applies to you. Here's your checklist. Number 1, keep insurance. I mean, it still helps with defense costs and minor claims, but don't stop there. Next, move assets out of your personal name. Use LLCs for real estate and business holdings. Next, use offshore tools for the next level of protection. Cook Islands trusts. Belize trusts, if you're already in a lawsuit because Cook Islands isn't too fond of taking on people who are already being sued right now, Belize doesn't care. Belize is less concerned if you're already in a lawsuit. Next, Swiss bank accounts or other private secured jurisdictions. Just a Swiss bank account alone will not protect you because a judge can simply force you to bring the money back. So it needs to be in an offshore trust over which you can have somebody who is licensed and bonded step in to protect you when needed. Next, separate your control. Now you can manage your LLC when things are quiet, but when trouble strikes, let the trustee step in to protect you. You can still go online, you can still see your account, you can still trade stock. You need to be in a position where the judge can't order you to turn the money over. Next, plan in advance. The best asset protection plans are done before the lawsuit hits. That way, they're nearly impossible for the courts to undo. And if you're not sure where to start, that's what we do. You can visit us at assetprotectionplanners.com. Get a lot of free info there. We've helped over 141,000 clients and have more experience with Cook Islands Trusts than anybody in the business. So if you're enjoying this insight, make sure to subscribe to this channel. We've got new content every week about how the wealthy protect what they've built and how you can do the same. In fact, in our experience, most estate planning lawyers won't tell you any of this. Why? Because they don't specialize in lawsuit protection. They focus on death planning, wills, probate, tax minimization, and so on. But what about lawsuit survival? I mean, we live in a country where one car accident, one disgruntled employer, or one mistake on a rental property could destroy everything you works for. Now, you've heard it said, hope for the best, plan for the worst, but for the wealthy, the worst happens to people like you, not by accident, but by design. Hey, you're just a payday to the lawyer. And the truth is, most asset protection plans fail because they rely on what's familiar, like insurance, and ignore what's actually effective, like offshore legal firewalls, layered LLCs, and trustee relationships. So this isn't about paranoia. I mean, it's about prudence. And the best time to get started is before somebody starts knocking on your door, serving you with lawsuit papers. So there you have it. Insurance is a good start, but it's not enough. So if you have significant assets, you really need a plan. And as the CEO of a law firm that specializes in this stuff, you need one that includes international trusts, protective legal entities, and advisors who know the difference between defense and deterrence. So if you're ready to protect your wealth before the system tries to take it from you, visit assetprotectionplanners.com. I'm the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been helping high net worth individuals protect their assets for over 34 years, and we've set up more Cook Islands Trust than any firm on the planet. So make sure to subscribe if you haven't, leave a comment below, and stay tuned for more videos like this one. Remember, lawsuits are a business. Don't be their next opportunity.